Well, it's 6 o'clock. Welcome to the Board of Zoning Appeals, Madison, Indiana, May 13, 2024. Could we have the roll call, please?
Scott Baldwin,
Here.
Mark Acosta,
Here.
Nancy Burkhart,
Here.
Rick Ferris,
Here.
Carl Eaglin.
Here. The minutes, board members, have you had a chance to go over the minutes last month's meeting?
Yes.
I have one observation on page 2382, where we were going through the findings of fact. I probably said something, but it's not recorded. So I move that we approve the minutes as submitted, contingent upon correcting the one thing I pointed out.
Second.
All in favor say aye.
Aye.
Opposed, no. And the minutes are approved. Moving on, we had quite a few renewals. They've all paid except one. The ones who paid is Prickett Properties, Jason Pattison, Patricia Danda, Riverside Tower, Gene Armel Investments, and Dugan Hollow Retreats, and we appreciate that. The one that is not paid as of our meeting, number 4, Indiana Apartment Holdings LLC. That's is a conditional use permit for an apartment complex, 132 East Street. Therefore, I move that we instruct our attorney to send the usual letter indicating that they have not paid their fees, their conditional use, however, will be renewed if they pay their fee by our next regular meeting. I made that motion. We have a second.
Second.
All in favor say aye.
Aye.
Opposed, no. Motion passes. Moving on, tabled applications, BZCU-24-4. That was Terry Jenkins' Legacy of Hope. That application's been withdrawn. So obviously, no more business on that. Moving on to new applications, we have one item on the agenda, BZCU-24-2. And I would point out to the staff, is that really do you want it to be BZCU? That means a conditional use. If you want to change that for the record.
It's VU. It's BZVU.
Because
24-2.
the notes I have call it CU, so it's BZ,
VU.
B,
Victor Urban.
VU, okay. Well, and for the record, we'll note that it's BZVU-24-2. Bob Vonch requesting a variance of use to allow a dwelling unit in open space that's located at 407 East Bond Drive, obviously zoned open space. So if somebody here wants to address that, please come up, give your name and address for the record, and tell the board what you want to do and why you're requesting a variance of use.
Bo Turner's my name. I'm with B&R Construction. Address is 1627 Fisher Ridge Road. What we're requesting to do is just add on above the existing footprint of the building, a second story to include 2 bedrooms. Keep the same footprint and the same hardy siding. Just go straight up, take back off from there. Same just be the same aluminum clad windows on the back side there. And we'll keep the same roof line, use the same type of metal.
So you're essentially adding a second story on the back part of it?
Yeah, that back part. The back part's just a single down. And it's just gonna come up and match, the same footprint and come up. Won't stick out any further.
Board members, or excuse me, staff, I believe our last flood that affected that property was what, in 2012?
Bob may be able to answer that better than I can, cause I wasn't here in 2012. I know that Vaughn Drive was underwater in 2017, but I'm not sure it
Okay.
affected this property.
Okay, I was curious.
Yeah, and this is above, here's above the flood line anyway, so this addition will be the second story.
And obviously you're in open space, which is, and on top of that, you're in the floodplain. Of course, per federal law, there's obviously, the floodway where the water really goes fast, and then the floodplain where it just rises. Board members, do you have any questions, comments?
Is this something that's gonna remain a rental, or is this something that's going to sell, or?
We're gonna stay upstairs and we'll probably rent it downstairs.
Could you come up, sir, and for the sake of our camera, and give your name and address, please, for the record?
I'm Bob Bonch, 1679 North Old State Road 62, own the property on 407. Yeah, we're staying upstairs, that's why we just wanna make it a little bigger. And it's got a the foundation, everything's all solid, so it's already established good, we're just gonna add above it.
Then what's for rent?
Well, sometimes we rent it downstairs.
Is that like an Airbnb rental, a permanent rental, or what?
We have some people come in sometimes, like regatta or something, like right now, it's open. There's nobody in it.
So we have friends coming in for a holiday weekend or something?
Right.
Do something like that.
So are you saying this is your primary residence?
It'd be half and half. We live on
Right.
1679, but we're down there on weekends and down there quite a bit.
So this is more like a weekend getaway type of a house, go and relax?
Well, more of a weekend, 'cause we're there during the week too, so.
And this proposed addition, is this for your use or for rental?
No, for ours. For ours. The upstairs. We'll keep the upstairs for us.
Board members, any questions, comments?
Let me clarify, really what this is, the variance of use, just to allow the structure to be there even as it is, right?
Correct, yes, it's
Really
current.
doesn't have anything to do with
No,
the
it's currently a
construction.
dwelling unit. It always basically has been historically, for quite some time, but since he wants to add an addition, he has gotta get a building permit.
Sure.
So we've gotta bring the use in conformance.
Okay, I wanna make sure I'm reading that right.
And I would point out that this is open space and there is no provision at all in open space for any kind of a residence. Although there are some, obviously, that have been there for a long, long, long time. Any other questions or comments, board members?
So Bob, you've owned it for quite a while, haven't you?
I've owned it, yeah.
Yeah.
Probably
And people have been staying there for quite a while too, since you've owned it, correct?
the downstairs.
Either spot,
We've always kept the upstairs for us.
yeah.
And it ain't our resident there.
Right, I
but
understand.
We go down there quite a
Right.
bit. We'll never rent the upstairs or nothing, it'll always be ours.
Right. And there's other places around there that people live permanently too, so I don't see a problem with it.
Board members, anything else? Would anybody in the audience like to speak for or against this proposed variance of use? Personally, I have a few concerns. This is open space. We have had in the past, I've been on the board, I think, 7 years now. We've had numbers of applicants that tried to put in camping kind of places. We've had other things like that. We've given conditional use permits with a lot of restrictions on them because open space here in Madison, Vaughn Drive is super special here. I mean, you just walk down the sidewalk and you see who financed it, people's names all over the place on the bricks. It's kind of like a micro version of Lakeshore Drive in Chicago. And personally, board members, I have a concern. A variance of use is a serious thing in my mind, because sometimes we have granted them a couple times. We granted a variance of use for a person off of Julieberry Way whose house burned, and she was trying to get it repaired, and that was zoned an industrial where no houses were allowed. But that was her house. There'd been a disaster. The house had burned. And so the board, we kind of smiled on her and said, yes, you can repair your house. But here we have a situation, in my view, board members, it's just my view, that there's no damage to the house, no flood, no fire. It's a desire by the applicant to increase the size of it. The zoning ordinance is pretty clear. Section 10, page 109. It's the intent of this ordinance to permit nonconformities, which your house is. Legally, it's considered a nonconformity because no residences are allowed in OS. Is the intent of this ordinance permit these nonconformities to continue until they're removed, so the zoning ordinance doesn't want to kick you out of your house, but not to encourage their survival. It is further the intent of this ordinance that nonconformities shall not be enlarged upon, expanded, or extended, and not be used as grounds for adding other structures or uses which are prohibited elsewhere in the same district. I mean, that's pretty plain language. Section 10.20, a nonconforming use of a structure, a nonconforming use of land, or a nonconforming use of a structure and land shall not be extended or enlarged after passage of this ordinance. The ordinance was passed in 2016, I believe, yes, 2016. There's another thing here I might throw in. Section 10.60, if no structural alterations are made, any nonconforming use may be changed to another nonconforming use equally or more appropriate. So, and they use the word shall, which in section 2.0 definition, shall, the language shall, legal meaning of it, which courts think about, means mandatory. So what we have here, board members, at least in my view, the ordinance is very clear that things that are non-conforming, sure, they go on. Nobody wants to kick you out of your house. But the ordinance says no additions, no enlargements. There's even a provision about if it is damaged less than 80%. I note that this is, well, it's a combination rental property. It's a part-time residence by the owner. It's not a primary residence where somebody lives there 24/7. There's no damage to it. It's merely a desire to make it a little bigger. It's in the flood plain, and there are strict rules about that from the federal government. So there's also a note in the ordinance that ordinarily variances are granted because there's some peculiar thing about the property, and that there's something that would make a onerous cost if the zoning ordinance is strictly enforced. Well, I'm not persuaded yet there's an onerous cost to not having a addition to for a weekend and an occasional place of residence. We have 5 criteria. Number 4 we'll have to answer after bit. Will constitute an unnecessary hardship. Is it an unnecessary hardship to go with a strict interpretation of the ordinance which says no, non-conforming properties cannot be expanded upon. And I'm also worried, from my point of view, board members, only mine, that we may set a precedent and other people now are gonna wanna add on to houses or do other things. And in the past, this board has pretty jealously protected open space down on the river because of how special it is. So those are my concerns, board members. If you'd like to answer them, feel free. If you'd like to say anything else.
I don't see how this addition is going to hamper the view of anything on the riverfront. The way it sets on this structure is actually gonna be further away from Bond Drive and the scenic view of the river. I just think it's gonna be an addition that Bob and his family can use on weekends and things to make it just a little more comfortable to live there, stay there. So I don't have a problem with this usage. It's not going towards the viewing area of Heritage Trail or the river, either one. And, like I said, the addition is gonna be on the north side of the building. Sorry, guys. So I don't have a real problem with this at all. And like you stated, that's my view, so.
Board members, anybody else?
Yeah, I guess my opinion is the ordinance language is very clear. That this is not an acceptable reason to grant a variance.
I might add a variance of use. The legislative body in Madison, which is city council, they passed this ordinance with the restrictions in section 7, which is about what you can do in each various zoning district. And the legislative branch passed an ordinance which said no residences, well, with, you know, the exception that if they're there, they can stay there. And having had some experience with judicial review of our decisions, I found that courts tend to go pretty much with the plain language, at least in my experience. If our attorney would like to chime in with something else, feel free.
I think just like the remainder of the ordinance, if the option allows for it, such as a variance of use, if the board wishes to approve it based on that, I don't see an issue with that. And that use has been that way for a long time.
Very true.
So Bob, let me ask you a question. So when you stay upstairs on the second floor currently, I mean, it's not very big up there, is it?
No.
So what do you even have up there? Do you have like a small kitchen or?
Yeah, there's a kitchen, bathroom, and then we got one spot where we have the bed. And then you can sit in front of all the windows.
Right, it's almost like a hotel room, I would think,
Right.
just from the size of it.
Right.
So in order for you to have like a bigger bathroom or something like that, you need to expand.
Well, I don't need a bigger bathroom.
But I mean,
don't
you need to
a bigger
expand just to
kitchen.
have some space, is what I'm.
Well, if I move that, where we got the bed there, that's why we wanna make the bedroom in the back. That would give us our space.
And there's already, the first floor is like 2 properties and you're just building up from the back end,
Yes, it's a
correct?
story and a half.
Yeah,
And your foundation is not gonna change.
Nope.
You're gonna build on
Just
the
go straight
existing
Yes.
footprint.
And it's a good solid,
It
it's
is,
block, brick, and
yeah.
the foundation's good, so it, I mean, there'd be a concern about if that didn't hold up,
Right.
then you're gonna lose the top, but it's,
No,
like I said, it's been underwater in the sixties, you know, and it's still there,
and like I said, same roof line and everything.
yes.
And in this application, technically, we're voting to either approve or say no to the structure as it is now.
For the use as a dwelling unit,
For that use,
yes.
yes. But we're not deciding anything about whether he can add on to the second floor.
No, that is
correct?
not this purview,
Okay.
this board's
Right,
purview.
right.
Just that if the property can be used as a dwelling unit.
That would come back through the,
Yeah, he's already been, before historic board for the addition. and then he'll have to follow all the floodplain regulations.
Gotcha, okay.
And this variance, if we do approve, is just for 407 East Vaughn.
So let me clarify my own mind. A variance of use here would be to allow a dwelling unit, even though the ordinance specifically says that a non-conforming use, which is a dwelling unit, can continue, because in this case it has continued, it's never been abandoned or anything. So is this, just wanna understand, you're saying that we should have, grant a variance of use so that a building permit can be filed, is that what the rationale is?
The variance of use would bring this property into conformance. It would no longer be a non-conforming use. So yes, the staff could issue a building permit since it has a variance of use for that property.
Then why haven't we granted a variance of use for the 2 or 3 other houses along Vaughn Drive?
They have not made any modifications that have required a building permit. If they have to, they would have to come through the same process or ask for a rezoning, which I don't know if that would go through or not.
So strictly speaking, this is just a variance of use to allow him to have a dwelling unit, but in fact, it's a precursor to being able to enlarge the building, have a building permit, and whatnot.
Correct, yeah. The property has to be in conformance with the zoning ordinance in order to receive a building permit.
So really, we're deciding whether or not he can, we're not just deciding that the place can stay there, obviously. The ordinance says it can, as long as he owns it.
This board is voting on a variance of use for a dwelling unit. Basically, to allow an exception to the zoning ordinance for that use on that parcel.
Board members, anything else? One last chance, audience. Anybody like to speak for or against? Okay, well, thank you very much. You can have a seat. We have to go through our findings of fact. I have an old findings of fact sheet which had 9 things, but the ordinance section 11.33 gives 5 criteria, so obviously we'll just be going over the 5. And since this is a big deal, a variance of use from the zoning ordinance, members, I would ask you to explain your reasoning for or against. And just as a simple reminder, this is a 5-person board, so it takes 3 yes votes to pass a favorable motion, or 3 no votes to pass an unfavorable one. Okay, number 1. Approval of this application is not going to be injurious to the public health, safety, morals, general welfare. Mr. Ferris.
No, I don't think approval of the application will be injurious, to any of those things.
Mr. Acosta.
I agree, I don't see this having any impact on anything.
Mrs. Burkhart.
No, I see no impact on those issues.
Mr. Eaglin.
No impact, and we're using the same foundation for this addition, so no impact.
And injurious to the public health, safety, morals, I think that one's met. Number 2, use and value of the area adjacent to the property will not be affected in a substantially adverse manner. Mr. Ferris.
No, I don't think, approval of the application will have an adverse effect on the, adjacent properties.
Mr. Acosta.
Yeah, I see no impact to the adjacent properties.
Mrs. Burkhart.
I see no impact as that building's been used in that capacity for quite a while already.
Mr. Eaglin.
No impact at all to the area.
one side, I believe there's a parking lot. So obviously it's not gonna harm that. And the other side is I believe a dwelling unit that's been there forever. I see no value. I think that one's met too. Number 3, the need for the variance arises from some condition peculiar to the property involved. And what is it? That is a big one. Mr. Ferris.
In my mind, we're trying to use a grandfather condition to skirt the written ordinance that excludes this particular use. And I personally can't get there. I don't believe that there's any peculiar condition to this property that would warrant approving this variance.
Mr. Acosta.
Yeah, I tend to agree with Mr. Ferris. It's difficult to identify peculiar to that property. I do see a peculiar occurrence along Vine Drive with a number of homes and buildings that are in the same condition, in the floodplain, in open spaces, different things. So it could be, might be considered peculiar in the sense that there are other like buildings, you know, in that area.
Mrs. Burkhart.
I find the peculiarity that it has been used for that, for quite a while. And I think we just need to bring it into conforming use as the neighbors are in that same situation. They just haven't had to come for this conforming use. But the situation's been there and it's been used in that capacity, and I don't see a problem with it.
Mr. Eaglin.
I don't see a problem with it either because the variance, like I said before, is just for 407 East Bond. They're using it for that now, just gonna be just some more space for them to use on their own private weekends and use, and just a little more comfortable for the folks.
Obviously, the peculiarity is the fact that that's open space, which does not allow any kind of residential. However, the building has been there for ages. And so the building is caught in this problem that arises with our zoning ordinance that modern day uses have changed, but the building was already there. There definitely is a peculiar condition involved here. Number 4, the strict application of the terms of the zoning ordinance will constitute an unnecessary hardship if applied to the property for which the variance is sought. So what is the unnecessary hardship which would require, which would be so, which would fit in with the whole business of having to make a variance of use? Well, Mr. Ferris.
I'm going back to the ordinance as it's written. This is not their permanent residence. And I don't believe that there is an unnecessary hardship here.
Mr. Acosta.
I'm gonna have to agree with Mr. Ferris to the ordinance as written, and the conditions that he mentioned. I don't see a unnecessary hardship as it exists today, given the use.
Mrs. Burkhart.
I see the unnecessary hardship as they wouldn't be able to use the property as they have for so long in the past. When they bought the property, they were using it as residence, and they've used it for that many years, and now all of a sudden they can't use that. I find that a hardship.
Mr. Eaglin.
I agree. I think by restricting this, we're causing the owners a hardship. I mean, all they want is just some comfortable space built out of the sight of anything that is in view of the river. I just think it's the hardship would be on the folks if we don't approve this.
In my view, is it an unnecessary hardship that a sort of a getaway enjoyment property, which is not primary residence, that's not been damaged by fire or flood or whatever, is that an unnecessary hardship that outweighs the very plain language of the zoning ordinance? In my view, I don't think that one's met. Number 5. This is another important one. The approval does not interfere substantially with Madison's comprehensive plan, Mr. Ferris.
I think it does interfere with the comprehensive plan. Comprehensive plan is very clear on having green space on Vaughn Drive.
Mr. Acosta.
I don't see it interfering, as it already exists on a footprint as is. I don't see that interfering with the green space area. There'd be no green space gained or lost through this application.
Mrs. Burkhart.
I agree, I don't see it interfering, because if they're not able to use it as a residence, then are you just gonna have an empty building there? And I don't think that's what the comprehensive plan.
Mr. Eaglin.
I see no interference with green space or anything else has to do with Heritage Walk or the view of the river. I think should be allowed.
The comprehensive plan is, well, it's both that large document that was written a few years ago, but it's also section 7.00, which outlines the uses allowed in each various zoning district. And the various parts of section 10 indicate that the zoning ordinance does not want non-conforming uses to be enlarged upon, although it certainly does allow for their continued use. And as far as a weekend getaway enjoyment type house, I don't think the issue here, in my mind, is not that they wouldn't be able to use it. It's just, it would, with an addition, sure, it'd be a better place, be more enjoyable. But does that outweigh the very plain language of the zoning ordinance? And in my personal view, as a board member, I think that one is not met. Well, board members, we have gone through our findings of fact. Now we will entertain a motion. Someone can make a motion to approve this variance of use or to deny it.
I make a motion to approve the variance of use, BZV dash 24-2 for 407 East Vaughn.
Second.
And could we have a roll call vote, please?
Rick Ferris,
No.
Nancy Burkhart,
Yes.
Mark Acosta,
Yes.
Carl Eaglin,
Yes.
Scott Baldwin.
No. Well, that is 3 in favor and 2 against, therefore the motion passes and you have your variance of use. We wish you well. Continuing on, old business, Camille Fife, Russell Linville, they have paid their renewal fees. Number 3 on the agenda, Kimberly Taylor, Jefferson County Transitional Service. Staff tells me that there are new owners.
There's this property owner is the same, but she's transitioned from on their board to just the property owner, so she would like them to apply for their conditional use in-house. So we're working with their board on applying for that.
So that conditional use has expired and will be reapplied for as whatever. And we have one last item of new business. We have a new secretary, Ray DeBaya. Welcome to the,
Welcome, yeah.
welcome. And in as much as you're our new secretary, I think legally we have to vote to make you such. So I move we designate Ray DeBaya as the Board of Zoning Appeals Secretary.
I'll second the motion.
All in favor, say aye.
Aye.
Opposed, no. You are the secretary.
Like it or not.
Trinity.
And unless I've omitted something, motion to adjourn.
So moved.
Second.
All in favor of adjournment, say aye.
Aye.
Opposed, no. We are adjourned.